Good afternoon, Your Honors.
Good afternoon.
May it please the Court, my name is Galen, counsel for the petitioner. In granting habeas relief to the respondent, the Ninth Circuit erred in improperly applying Smith v. Illinois to this right to silence case. Their logic in doing so was that under the 2010 ruling Burgess v. Tompkins, right to counsel cases such as Smith and Edwards v. Arizona apply to right to silence invocations such as the one relevant to this case. And under modern case law, they would be correct. However, Tompkins should not apply retroactively to a decision that was issued before the Supreme Court issued Tompkins. Now, the assumption in our legal system is that any decision will apply retroactively. However, there are exceptions to this rule. And Solomons v. Stooms, a 1984 case on the retroactive application of Edwards v. Arizona, another right to counsel case, laid out a three-part standard, a three-part test for the non-retroactivity of a decision. First, the purpose of the decision must not be to enhance accuracy in criminal trials. Second, law enforcement officers must have relied heavily on the old standards. And third, retroactive application of the decision would have to have a, quote, disruptive effect on the administration of justice.
Let's talk about that second element, the idea of law enforcement and relying on a specific rule of law. I want to hear what you have to say about that. That seems like there's probably case law going both ways here on the application of context to an alleged invocation.
Is your question regarding the retroactivity test or more broadly the case law?
Yeah, the retroactivity test. Well, as applied here, I suppose.
Right. So in Solomon v. Stooms, the court ruled that Edwards does not apply retroactively. Edwards is a right to counsel case and fundamentally deals with the same subject matter as Tompkins. Tompkins, in effect, applied Edwards and other right to counsel cases to right to silence. So this question of did law enforcement officers rely on it is based on what practices were considered best practices at the time. Before Tompkins, there were substantively different standards for right to counsel and right to remain silent, as you see in a decision like Edwards in right to counsel and Mosley v. Michigan in right to silence. So what this case is dealing with isn't the underlying rights, because those are protected regardless. What it's dealing with is these prophylactic safeguards to protect these rights. And it's clear in the solemn ruling that Edwards meets this test, and Tompkins, as it's dealing with substantively similar matters, also meets this test and shouldn't be applied retroactively. Now,
with Tompkins in particular, this troubles me because I think that the decision of Tompkins itself, the court recognized that there was really nothing unique or new about its ruling. And the court sort of didn't go that far in saying that, but it sort of said we see no principled reason not to apply the standards differently. And so does that suggest that there really wasn't anything super novel about that decision that should trouble us about its retroactive application?
Not necessarily. Tompkins, like Edwards, didn't overturn any previous decision. It was changing the nature of the prophylactic safeguards, however. And while the court may be correct that there is no principled reason to have different standards, there were nonetheless different standards. As I mentioned earlier, Mosley v. Michigan allowed an officer to return, re-Mirandize, and resume questioning on a suspect who invoked his right to remain silent. The same was not true for the right to counsel. So even if these differences may appear minor, in terms of police practices and admissibility of evidence, they can make substantial differences in a large number of cases, which also is relevant to the third point in the Stooms test, that retroactive administration would have a disruptive effect on the administration of justice. What applying this retroactively would allow is a whole slew of new habeas petitions on matters where the Tompkins ruling may have been violated, but police officers were following the best practices at the time. So without the benefit of Tompkins, we can't rely on Smith to discount relevant context either. And under AEDPA, the federal courts have to assume that the state court, doesn't have to assume, cannot grant relief to a state court ruling unless there was an unreasonable application of the law. And without a specific ruling, such as Smith and right to counsel, saying that context can be considered, there was no unreasonable application of the law, and thus the Ninth Circuit's ruling should be reversed and remanded. Thank you, Your Honors.
Thank you, counsel.
Thank you.
Whenever you're ready.
Good afternoon.
Good afternoon.
I too am here to support petitioner in the case, appeals case, of California State versus Jones. The court should reverse the decision of the Ninth Circuit Court of Appeals because the officers did not interrogate Jones after his alleged invocation of his right to remain silent. Smith says that once a suspect invokes his right to counsel by word, officers must stop questioning and must stop questioning the ambiguity of the statement. Tompkins tries to equivocate the right to counsel, as mentioned in Smith, those standards with the right to silence. However, Tompkins occurred in 2010 law. In 2008, that's when the appeals decision occurred. 2006 is when the interrogation happened. So it's unfair to say that the cops were violating Smith's rights to silence when they didn't even know about the law itself. This means that a person may not be interrogated unless the suspect unambiguously says that they would like the right to remain silent. Jones never invoked his right to remain silent because the overlying context states that he was brought in, he was talked to for 3 hours, he changed his story, and then somewhere down the line, he mumbled that maybe he doesn't want to talk anymore.
What allows us to look at the context here? I think that's one of the issues that the dueling sides here in the courts were struggling with is, are we allowed to look at that context, or are we only allowed to look at the statement itself? And so what legal precedence allows context to be looked at in order to cast doubt on an invocation?
Well, we're looking at Smith. We're looking at whether or not he unambiguously or ambiguously invoked his right to be silent. Actually, sorry, we're looking at Tompkins. But as I said before, that's hard to justify in this case at hand.
Well, so Smith tells us that we can look to, for example, everything that happens before an invocation. We can look at the nuance of a discussion to see whether there is something confusing happen that would call into question the invocation. But it doesn't allow us to look at events that happen after the invocation itself. And so can you talk a little bit about what happened before the invocation that caused the ambiguity here?
He was questioned. He was asked about what he knew about the crime itself. He was asked about statements about what he said about the crime, but not necessarily about his participation in it.
And that's pretty normal, isn't it, for in any interrogation to be sort of asked about what happened and, you know, what was your role and that sort of thing. And so the statement itself, I don't want to talk no more, seems rather clear. And so what basis did the trial court have to rule that it wasn't clear?
It was clear in context, but the nuance was that he started to interrupt the cops after he was supposedly silent. And this brings me back to the next part of my appeal to this court, is that the cops theoretically never really interrogated him after he said that. So if Tompkins' law was to be in effect at that moment, the cops would not have been violating his right to be silent.
And so what leads you to that conclusion?
My conclusion is this, it's that I'm appealing to reason. There has to be some fine line which some questions could be allowed and where some can be disapproved. And that's why it should be reviewed.
Thank you, Counsel.
Thank you for your time.
All right.
All right, well done, guys.